Yes, please.
May I please, Lordship? Lordship, I beg to mention one read appeal, Lordship.
Read appeal.
Yes,
Why?
Lordship, Chief Justice asked me to mention in this court.
So what is that? What is that?
Lordship, it is a Panchayat matter.
Panchayat.
Lordship.
What?
Lordship,
Panchayat?
no confidence motion will be held on 9th.
9th.
Planning will be listed on tomorrow.
9th. 9th is
9th January.
January. And today is 4. 5. Have you filed a writ appeal?
Yes, Lordship.
Already registered?
Already registered, Lordship.
Okay. Day after? Friday?
Friday. Obliged, Lordship.
6.
May I please, Your Lordship? Your Lordship, I would beg to mention item number 20. As the senior counsel, Mr. J. Roy, is having some personal difficulties today. Your Lordship may fix this matter after the Bihu vacations.
Item number?
20, Your Lordship.
Bikash Upadhyay. What is this case about? Do you have any idea?
It is an APSC matter, Your Lordship.
APSC matter.
APSC selection.
Why it is listed today? Do you have any idea?
No.
No idea. There may be some reason for existence. Nothing exists without reason. So if it is listed today, there must be some reason. Nothing is accidental. Huh? Even accident is caused because of negligence of somebody. There is always a cause. Nothing happens out of the blue. So it is listed for what purpose?
Orders, Your Lordship.
Huh?
It's listed under orders.
Yes, but why it is come under orders? DB2.
Last opinion to no place affidavit on behalf of APSC has been found.
Advertisement APSC holding competitive. Regarding what competitive examinations? Key answer. Mark obtained read appeal. Ranjit Kumar. Who is for the other side? APSC? Yeah? Is there some TJ Monto? We can see a lot of cases also being cited earlier. How separate yardsticks.
Listed for that.
But why it is listed for other? Huh? You also don't know why it is listed. Total clueless, huh?
IA for stay.
IA for stay.
That's why it is in the order column.
IA. Yes. IA. Bikash Upadhyay. Stay the appointment of selected candidates 2018. 20. So no stay order was filed. Huh? Why you want after Bihu vacation? Why not tomorrow?
Tomorrow, Your Lordship, if possible, it can be listed day after tomorrow.
Are you sure?
Or Monday.
This is a selection of 2019 ability.
We had heard this in January 22. Last year, January.
Oh, see.
Huh? Then you all slept. we slept, file slept. 3/1/2022, we recorded some order. Of course, a different bench.
Said
Huh?
Lordship, in the month of June or July.
Grace mark, can you refer the number? Grace mark have been wrongly given.
Yeah, that's what we want.
Then after adjourned. It was hard on 3/1/2022. Then this again on 3/1 after 3/1. Then 31/1, Mr. J. Roy. If you Dotto 6, which time? Mr. Dotto, who is Mr. Dotto?
PP dot APSC.
APSC.
TJ Motor Junior.
He wanted to some latest position. I don't know what is this latest position. Then heard Mr. Sharma, joint prayer. Then both the lawyers agreed. Very rare. Lawyers don't normally agree, no. There's always a difference in the court. We don't see agreement of lawyers, but in some cases, the lawyers' agreement is very fast, especially adjournment. But otherwise, the lawyers will fight tooth and nail in the court, no?
Then affidavit.
Affidavit. Sharma submits the necessary affidavit will be filed on behalf of APSC. Yes, Sharma. Huh?
Sure.
We wanted to file shortly. That was in March, before Rongali Bihu. Rongali Bihu is in April, Nagi. Eh?
Yes.
That was Rongali Bihu. Then on the prayer of J. Roy, instead again 4/4. E. Nath. J. Roy. E. Nath. You are E. Nath.
Yes, yes.
So all are recorded. Your names are recorded. Huh? Then office notice. Office, no fresh affidavit on behalf of APS has been filed till date. Yes, madam, are you going to file, or you, when the matter is taken, we said, please give us some more time. Shortly, you mentioned shortly in March 22. Now, New Year has come. And we'll wait for another New Year to come. Because New Year will keep coming. Yes, are you have any instruction that you'll file, or just floating like this?
Lordship, you'll have to go to the matter and Lordship.
When will you go through a matter you listed today?
Lordship,
When will you go? When you go through the matter? Then we'll adjourn for 1 year then. You take your time. Shortly, if you could not file shortly, list a matter of the 1 year on the parallel line counsel for the parties. Yes.
May I please your lordship? Lordship, I beg to mention for item number 1, lordship. Lordship, my senior is out of station.
Item number 1.
Yes, lord.
Do you have any idea about this case?
Lordship, here the petitioner is declared as foreigner.
Then what to do? Then?
I think lordship record is yet to receive.
Sorry?
Record is not yet received.
It was not received. Anyway, you wait for some time. Yes, any other?
Lordship, for listing the motion matter. For an
Monday.
lordship, kindly Friday, lordship.
Monday.
Daily list for motion item 1.
Yes, item number 1. You on adjournment? Huh? Ajufa Khatun. You on adjournment. Let us see what is the problem as well. On the prayer of Miss M. Bora. You are M. Bora?
Yes, lordship.
December 2022. And before that, 29/5/2019, none appears for the petitioner. 15/5/2019, on the prayer of Miss Diori. Oh, this matter has not been moved at all. After you filed the petition in 2019, you have not moved at all. You have not started the engine. Before you start a journey by motorcycle, you have to start the engine, isn't it? Huh? Just sitting in a motorcycle will not help you, no? Even if you fill the petrol, tire is okay, brand new vehicle, unless you start the engine, it will not move. We have not yet started the engine. The matter is lying here. So you expect somebody passerby to start the engine, it will start. We can start the engine also. We can issue notice. Because we know that you are not interested, it appears, I don't know. But what will happen if you, as per the affidavit, file a petition record? What is this? You file some affidavit also.
15 side, already 15 side of our.
PAN card. Ajufa Khatun. Okay, we'll issue notice. What is your name?
M. Bora Lordship.
And Miss M. Bora, Lane Council for the issue notice in 4 weeks. Call for the records. And is there any order has been passed against you? Impugn order. Ajufa Khatun. You are still outside or inside?
Outside.
Outside. Outside where? Outside the country or outside your home? Home. If you are outside the country, then we can't. Home. Outside the home. Okay. You want to remain outside or inside? Which one? What do you want? Anything else you
Outside.
want?
Lordship.
You want to remain outside? Outside what? Outside detention?
No, Lordship, in time for.
Inside detention? Which one you want? You have to make prayer. You have to go somewhere. Even starting the engine will not help.
Lordship,
You have to,
not-
there are so many roads. Some road are going to Nagaon, some road are going to Morigaon, some are going to Tezpur, some are going to.
Lordship, not.
Which
to-
one? Which?
Not to arrest and
Not
deport.
to, okay. Do you watch Crorepati? Kaun Banega Crorepati? Do you watch? Then Amitabh Bachchan says, you have to say from in your own mouth, log kar dijiye A. Otherwise he will not proceed. Then the participant has to say, A ko log kiya diya jaye. Then he will proceed. So unless you say, how can we? Okay. In the meantime, if the petitioner has not been detained on the strength of the offense.
Prayer for bail is not here.
Hmm?
In the prayer portion, prayer for bail is not here.
That's what we are saying, no? They don't know. See, they are not, I don't know. They are not in touch also, perhaps. Then after she is detained, then she will come running in the court. Yes,
Item number 2.
Kasar Ali. Yes, Kasar Ali. What is this? Kasab Ali. Kasar Ali, Kasab Ali. Kasar Ali. Since the records have been received, the matter will be listed for hearing.
Item number 3.
3. Sahajan. Where is Sahajan?
May I please,
This
Your
is
Lordship?
Jamiran Nesa?
No, something different.
Some the wrong file negated.
This is.
3535.
3535.
35 Sahajan Ali.
3435, find that I'm in respect of 3535.
3535.
Item number 7.
Yeah.
Jamiran Nesa, item number 7 again. Then where is item number 3?
May I,
6, 7. You are item number? Sahajan. No, Kasar Ali. You are Kasar Ali, no?
Very good.
This is Shahjahan Ali.
No, but we are taking up number 2, no?
Number
No,
three.
number 3.
Yes,
Number 3. Okay. Number 3, Shahjan Ali. You are Shahjan Ali.
Lordship, kindly pass over the matter.
Pass over the matter. Pass over. Pass over. Why pass over? Huh?
My senior is at another court.
Your,
Senior is at
who is your senior?
MU Mundal.
Huh?
MU Mundal.
M.E. Mondol. He is busy in another court. Which court number? Which court number?
Correct. Court number 4.
Court number 4. One matter. What is the matter? Which matter is that? Which matter is that? Okay, for the time being. Yes,
Item number 4.
Sahidul Islam.
May I plead your lordship? Record, LCR has come.
LCR has come. Okay. Since the records have been listed, the matter will be listed for hearing.
Item number 5.
Shiraz Ali.
LCR received, my lord, let it come for hearing.
Okay.
Item number 6.
Yes, my lord, the petitioner is outside, my lord, and her nephew, the son of her brother, one of her brothers, he deposed as OPW2, and brothers are still alive. They are also voting, my lord.
Okay. Notice record interim.
Item number 7.
Item number
7.
Jamiran.
Yeah.
Jamiran, yes.
Usually LCR has called for and bail is granted in Miller.
Notice since the records have been listed, the matter will be listed for hearing.
Item number 8.
Mumtaz Begum,
LCR received my lord.
same order.
Item number 9.
Saleha,
In this case, my lord, this case is filed.
when did you file the case, this petition?
Yes, they are
When did you file the writ petition?
in 2019.
19. Then after that, what did you do?
That matter has not been listed, but
Why?
Not yet. Great.
Why it was not listed?
there is some problem is there, but after filing of this petition, the
Hmm.
petitioner informed that in another case, they have been declared as foreigners in between 66 to 71. And accordingly, they registered their name in that case.
And then,
So that petition order was not placed before the tribunal below in this case, my lord. So now they place this record. They asked me to withdraw this petition, but I advise no, it cannot be withdrawn. That is why it was not listed. So I
Then
got the that
you
order.
gave your advice in 2019. After that, after giving the
But I-
advice,
But I
yeah,
am.
you also slept off because
Yes.
see, lawyer's advice is very precious, no? You can't give advice after advice, no? Because advice is value loaded. No advice is free.
Even they.
So once you have given advice in 2019, you thought that if you give another advice, that will be
Even when
price
they-
tag will be there, no? Some price tag is there in some advice. Yeah.
Right.
So then,
even they.
since the price they were not willing
Yes,
to
sir.
pay, so you didn't give the advice again.
So
You kept quiet.
That is, I want to file one additional affidavit, my lord, to bring on record that. And even they written letter to me.
When did they write the letter? Which, when?
It is 28/8/19.
But only letter, no?
No.
Plain paper, not with this Gandhi.
So that is why I asked them to know it.
That's why you are not interested. You require a paper of particular paper issued by the RBI.
Then
This
they-
A4 size paper, plain paper will not help.
But they.
That's why you didn't say anything for 3
they-
years,
they
19, 20, 21, 22, 24 years.
They produced those documents recently, my lord. When I asked them, then you bring this record, then they bring this record recently, my lord. I have found that in that case, they also declared between the stream and they registered their name. This is the record recently I received.
Mr. J. Ahmed prays that he may be allowed to file an additional affidavit. Praise allowed, at least after a month. You file it.
Item number 10.
Item number 10.
Yes, it's the expiry order, my lord.
Hmm?
Imperial order is page 18, my lord. His father's my lord,
What ex parte order?
page 18, my lord.
Why it was ex parte?
And subsequently, he was not appeared, my lord.
And you also didn't appear for
He
4
initially
years.
appeared, my lord. now
You also
subsequently-
did not appear for 4 years after filing the petition. So why should we decide ex parte against you also?
This case has not been listed, but
Listed, not listed.
not listed.
Then you also didn't say anything.
From 2019, my
It was
lord.
listed on his prayer. It
Oh,
was absent.
One occasion.
List after ensuing summer vacation. It was listed on 25/6/2019.
On the prayer.
The summer vacation
My
came. You
lord.
enjoyed the summer vacation. Then the winter
And after
vacation
that, my lord,
came.
this case
And
has not been-
then the Bihu vacation came. So many Bihus, so many. Huh?
Even when I, even
For
when-
4 years you are waiting. Suddenly, one fine morning in January 2023,
23, my lord.
you realize that there is some matter which you totally forgot. And what is this? What is this reason for this amnesia? Why we forget? There must be some reason for forgetfulness, no? If somebody keeps on reminding you, you will not forget. He has not reminded you also. Who is this lady or gentleman? Monis Ali.
Mommy, my lord.
Monim, huh?
Mommy, my lord.
He forgot to remind you, or he was afraid to remind you. Two things.
My lord,
Either he
due-
forgot
due
to remind you,
my lord, in the-
or he was too afraid to remind you.
my lord, in the meantime, that
Because he
COVID-
knows if you remind him, you will say something which he can't comply. Then a problem. Why it was listed now? It could have been listed after 1 year also. It can be listed 2014 also, or 24.
Generally, the notice is not an issue.
In the year 2016, impugn order was passed. Lordship.
And he filed in 2019.
19,
Then you
Lordship.
forgot.
In-
Then you can move in next year also. What is the hurry? There is no hurry. If you could wait for 4 years to move this petition, I'm sure you can wait for another 4 years also.
my lord, during the COVID, my lord,
COVID, again, this poor COVID. Huh? Oh, COVID has gone. It is there in some other country, just next to us, north of this country.
In 19, there was.
But it has not come again. Now you are again blaming COVID. If COVID was alive, if his COVID spirit is there, he will blame you. Why you are blaming for all the problem you are having? COVID went in since 2021.
21.
Huh?
21.
From March to 2020. Lordship.
Then 22, now 23.
23.
What is the ex parte order?
Expert order.
Why? But why it was an ex parte order?
Initially, he appeared, my lord, but subsequently he has not appeared.
Why? Subsequent, why didn't he appear?
Rather same cause, my lord.
What same
The
cause?
financial condition, my lord, did not appear.
But
Even my lord, his father's name appeared, my lord, in the notice of
see, the
citizenship.
same problem will have, because he will have the same, it appears that he is having the same financial problem because which he cannot appear before this court for another 4 years. Therefore, we don't know whether he will be able to appear in the foreigner's tribunal even if you remand it also. We will say that I don't have money. Then how will he contest himself?
Now, my lord, he may be appeared, he will appear. but-
He has improved now. His
He's
financial
improved.
condition
He's
is
improved.
improved.
That's a remind me,
Huh?
my lord. That's a, he remind me. Even but honestly, Simon, I'm forgetting this case, my lord.
The truth is
From
coming out.
2019, my lord, foreigners case, my lord, I think that, my lord, this was admitted, my lord. But suddenly came, my lord,
Let the records come. Lordship.
on the made part, my lord, his
But
father's-
then we say, okay, but what is the basis on which you are claiming that you are an Indian?
My
Tell
lord,
us.
his father's name appeared, my lord, in the voter list of 1966, my lord, 70, my lord. That's page
What
12,
is your
my lord.
father's name?
Page 12, my lord.
What is your father's name?
Father's name is my lord, Mazom Ali.
Majum Ali.
Malik.
Majum Ali.
Page 12, my lord.
Okay. And your mother's name?
Mother's name, my lord. And my lord, page 13, my lord, is a Mazom Ali, is here, my lord. And my lord, page 14, my lord, this is Momi Ali, father of Mazom Ali, my lord.
Just a minute. Majum Ali,
This
Majum
is a
Ali.
voter list of 97, my lord. Page 14.
1997. Who is this Momim Ali?
The Momi Ali is a petitioner, my lord. His father's name is Mazom Ali, my lord. And my lord, previous page was page 13, my lord, Mazom Ali. Name is appeared, my lord, in the voter list of 1970. And my
Your
lord,
father was staying in Madrasa Para.
But the same police station, my lord, in the year 1970, my lord.
And 1997 you moved.
On the same police station, my lord.
Eh? Same
Belsor,
place.
my lord, under same police station, my lord.
Belchara.
Belsor, my lord.
But earlier it was not Salmara.
Or not, sir, my lord. But within the same, my lord, police station, my lord.
You are in the same house over. Momi Mali or Bhoipuri. Balchara. Balodcha. Balodcha. Balodcha LP school. Balodcha.
Oh, where we want the same police station, Golpa.
Are you sure you are Indian? Because we don't know, because your father was in South Salmara, then you are in Abhoipuri. South Salman, okay, not division.
Police station, same, my lord.
Police station same.
Oh, where we want, my lord.
Abhoipuri. No, not Salmara.
66,
Golpara, huh?
subdivision of
Golpara.
police station,
Not
not Salmara.
Salmara.
Subsequently,
Abhoipuri.
subdivision has become not
Salmara.
Salmara because
Subdivided. Abhoipuri.
but
Village is
Banarsor, and here village is Madrasapara. Village is two different villages. Otherwise, Gwalpara subdivided this Gwalpara was because in Pulisivan is not Salmara, it was under
Saved Ali. No, but then Mr. Sharma, let him go and apply, otherwise. But we make a
Petitioner first time appeared in the year 2009, Lordship.
anyway, he should appear now, otherwise, see, problem is that Mr. Sharma. There is also a problem from your side. He has been declared foreigner 2016, but you had allowed to stay here, cast his vote. Whom did you cast your vote? He cast his vote. We have been staying here. We have been earning money from this country. You are not doing anything. 2016, he is declared a foreigner. He should have been sent to Bangladesh. And today is what day? 23. How many years he have been staying here? 6 years. More than, huh? More than 6 years. 7 years. He is there in 7 years. So he says, give me, I have become an Indian by now. I have casted vote for so many. One election he must have cast, you know. Likho Han Mr. Land Council. Considering the nature of the case, we are inclined to allow this petition at this stage without issuing any formal notice to the respondents. In this petition, petitioner challenged the ex-party order dated 38/2016 by which he was declared to be a foreigner on his failure to appear before a tribunal to contest the reference made against him that he is a foreigner, not an Indian. Petitioner submits that the petitioner could not appear, could not pursue the case before a tribunal because of his financial. Have you mentioned anywhere your financial
My-
problem?
my-
Where is that para number?
My lord. Page chairman.
Para, where is it that you are a poor man and you cannot afford? Where is it? You have not mentioned anywhere. Only blaming the lawyer. Para 15, eh? Have you mentioned, this is Monishali, you are Monishali, no?
Momi.
A poor person when he went to Tamil Nadu, that is why. Because of his financial condition, he had to leave the state to earn his livelihood in the state of Tamil Nadu. And as such, there has been some communication gap with him and his lawyer, resulting in failure to be represented before a tribunal and being proceeded ex parte by the tribunal. Petitioner submits that petitioner has otherwise valid documents to show that he is indeed the son of one Mazam Ali and Mohela Bibi, who were residents of Madrasa Para within Deed and Gwalpara district, undivided Gwalpara district, as evident from the voter lists of 1966 in respect of the said LAC, wherein the names of his parents, Mazam Ali and Mohela Bibi, have been shown. Similarly, in respect of voter list of 1970, in respect of Abhaipuri legislation constituency, in respect of the same village, the names are reflected. He also submits that submits that in a voter list of 1997, his name is also shown as the son of Mazam Ali. In 1977, as well 2011 voters list, his name is shown as the son of Mazam Ali. What is this annexure B3?
Futalis matter,
It is not certified copy.
18 and 19 matter.
18 and 19. Is it shown as D or what?
Matter, no matter, not G matter.
Even submitted that the names again shown in the voter list of 2018 and 19. Unfortunately, because of the non-appearance, because of his non-appearance for the reasons stated above, the petition has been declared to be a foreigner by an ex-party order date 38. We have considered the no, but we had gone to tribunal also.
Yes, Doctor.
There is specific, send the petition. Huh?
There is some,
You are not able to say, there's a problem. No, you don't come prepared at all. You say just one sentence and you expect the court to decide everything. Then we'll go home, take all this file with us. We'll aram se dekhega. We'll see and decide the case by seeing these records. We don't need the assistance of lawyers. Why do we require?
The people who thinking and review him after the decision is over. He's so careless.
In the year 2009, he has
That
appeared.
evidence on affidavit also, it seems, it should be more clear.
We have filed an application for review. It was not allowed. It has been submitted that subsequently the petitioner approached the tribunal for reviewing the said order dated 38/2016. However, the learned tribunal declined to review the order in as much as there was an inordinate delay in filing there was a delay in approaching the court, tribunal. White order dated 22/12/2016. Full stop, next para. The said order dated 22/12 also have been challenged petition. We have perused both the impugn orders dated 38/2016 and the 22/12/2016. As regards rejection of the application for review on the ground that it was delayed and that the tribunal has no power to condone such a belated application, this court has already held in. Yes, somebody can give us, yes, some decision we have already passed. You didn't come prepared also.
Today I have
Oh,
produced it.
today then why are you just standing? You should have said in the morning, please pass over. You could have sent some junior and said, please pass over.
Remember that
Yes, this court has passed, has decided in WPC number so that the tribunal can entertain, can condone, has the power that the delay can be condoned. Accordingly, we have the view that considering the evidence, considering the nature of the case, condone, full stop. Next paragraph. Considering the submission advance in the material record, we have the view that petitioner may be afforded another opportunity to appear for a tribunal. And accordingly, we allowed this petition by setting aside the impugned order dated 38 to the ex parte order dated 38/23, as well as the order dated 22/20 pass in miss case number, page 19, 18/19. Petitioner will appear before the tribunal when? Give a date. When will you appear before the tribunal? Is it in Tamil Nadu or where? Is it in Assam right now?
Right now in Assam.
Huh?
Right now.
Are you sure?
I'm sure.
Don't go to Tamil Nadu after this
Right now
again.
is in Assam.
Huh?
Right now is Assam.
Right now, when he will appear? Tell us.
Within 1 year, 1 month, madam.
Huh?
Within 1 month.
1 month. Give a date. You are the one who is going to appear. Give us a date.
First week of February.
Again, date.
3rd of February.
Huh?
3rd of February.
Make sure that there is no bun also on that day. On 3rd of? 3rd of February is what day? Friday.
3rd of Friday.
Are you sure you will be able to appear on Friday? You won't be able to appear on Friday. There is reason we know.
I will not appear, madam. Before
No,
that.
this gentleman,
This is where he will appear, madam.
on Friday it will be difficult for him. Arey,
7,
don't-
madam.
huh?
7, madam.
7. Because we know the reason. Huh?
Without fail.
Without fail. And if file his written statement and also and adduce evidence in support of his claim in Indian or foreigner. Learned Tribunal Director will pass appropriate order as regards the status of citizenship of the petitioner. It also made clear that in event the petitioner fails to appear before the tribunal on 7th, this order passed will stand recalled without any further reference of this code. And a law will take its own course. Also, it also provided that if he appears before a tribunal till culmination of the proceeding, he will be allowed to remain on bail. However, he will appear for the SP border. SP border.
Bongaigaon.
Bongaigaon.
Baki
And the
sab
citation is madam 2011 5 GLD 734. 2021 5 GLD 734.
You have to give a cup of tea to the ghost in the afternoon. Huh?
I'm sorry, madam.
Anything.
Extremely sorry, madam. I have lost the file.
Mr. Khadikar, sometimes we take it to be a misconduct on the part of the lawyer.
I'm
It's not expected.
extremely sorry, madam.
No, you better be sorry.
Next.
Item number 11.
May I please your lordship? My lord, here records are here. My humble prayer before lordships will be to remand back the matter before the learned tribunal
Why?
to decide the matter afresh.
Why?
First reason is that lordship, my brother has adduced evidence as DW2.
And there is no reference to that. There is no
There
discussion.
is just discussion about it, but whether that evidence was accepted or rejected, that opinion was not called out. May I read that relevant portion, lordship? Page 18, lordship.
Yes.
DW2, Badsha Mia projecting brother of proceedings submitted evidence on affidavit and cross-examined. In his cross-examination, DW2 deposed that his father expired 10 years back. He also deposed that his parents casted their vote in the year 1989. He also deposed he cast his own vote in the year 2005. But his entire evidence, if we go through lordship, which is at page 30, lordship,
Three
30, lordship.
Yes.
And he stated everything on affidavit.
And even his mother was declared as an Indian by judgment dated 21/11/2014. And his cross-examination part also, even he had stated that he has adduced evidence, but that was not considered. And just only discussion is there, but whether it is accepted or rejected, that part is not there, Lord.
Yes, Mr. Sharma, what do you say?
I have to see the record. Lordship.
No, you see, what record, you just read the order. Order itself says, DW page 18, DW Badsha Mia, so and so deposed. After that, I know reference to this DW2. Then goes on that
It is true,
mere filing, then if under the administrative law, as we understand, if a relevant fact or material has not been considered by the concerned authority, it amounts to non-application of mine. And so, because Badsam is a very relevant, his brother, real brother, younger brother, elder brother,
Elder brother, Lord.
elder brother. So elder brother would know when his younger brother was
And
born.
on affidavit also he had stated.
Because
"I'm
the elder brother
brother."
must have taken him taught him many things in life, how to walk, how to catch fish, how to, pick up orange, mango from the tree. The elder brother will teach how to run away also. Hmm?
He has building cross. He has reaffirmed everything.
Yes. And the cross-examination, he has reiterated what he stated in the exam. Even therefore, his evidence shall be treated to be unshaken. That evidence, that piece of evidence you cannot ignore. If it is ignored, then the decision will be rendered illegal. So on that ground, we allow this petition without referring to. Our Ms. Dekho. Our Ms. Ghosh Lane Council, also Lane Council. Considering the nature of this, since the records have been received, however, considering the nature of the case, we have the view that the matter requires reconsideration by the tribunal. We may not refer to the detailed facts of the case in MHS, but it will suffice to mention herein that the petitioner having proceeded before the tribunal, before the Foreigners Tribunal number 1, Borpeta, in FT case number so and so, page 14. Filed his written statement and also adduce evidence, including by examining his elder brother, one Badsha Mia as DW2. However, at the time of giving opinion, though the learned tribunal mentioned about the giving of evidence by the said DW2, did not analyze or discuss the evidentiary value of the said Badsha Mia, who the petitioner projected to be his elder brother. We have gone through the records. The said Badsha Mia was indeed examined by the tribunal, and he was also duly cross-examined. We also noted that in the cross-examination, he reiterated what he stated in the examination chief. Thus, his evidence has remained unshaken. If that is so, we have the view that that is a very vital and this is not only relevant but also vital and important piece of the evidence which could not have been ignored by the learned tribunal while considering the citizenship of the petitioner. Though the learned tribunal has referred to and mentioned about other evidences, we have the view that we may not go into the same in which is once a relevant and material piece of evidence or evidence had not been taken into account by the decision-making authority, such decision arrived at would be vitiated on account of non-application of mind on a relevant material. Under the circumstance, we have no option, there is no other alternative but to set aside the impugned order dated so and so, pass the learned foreigners tribunal is vitiated due to non-application of mind on a very vital piece of evidence, that is the evidence of Badshah Mian, who the petitioner projects is to be his elder brother. We also make it clear that it may be also noted that while the learned tribunal an according matter is remanded to learned tribunal for fresh reconsideration, it may be also, we also would like to observe that the other evidence on record has to be also examined by keeping in mind the evidence of GW2, in as much as the evidence of an elder brother would certainly change the color and context and contour of the evidentiary value of other evidences. In as much as before the learned tribunal comes to an opinion, he must take into account the entire evidences holistically before arriving at his own conclusion. With the above observation, direction the president allowed, impunity set aside, finish the if the matter is remanded to learned tribunal for fresh reconstruction. Petitioner will appear before the tribunal on, give a date,
On 7th of
7th
February,
of February, so.
may I submit lordship? Subsequently, Jamabandi is there and other voters list also of her parents. She may be allowed to file it.
She, Manwara Begum.
Yes,
Okay.
lordship.
It has been submitted by Ms. that subsequently after the opinion is rendered, a petitioner came across some more documents which would support her claim that she is an Indian, but which she could not rely on in a way that these were not available at the relevant time. These are aspects the learned tribunal also will consider if any application is made by the petitioner, which shall be considered in accordance with law.
But in repetition, it was not paid lordship regarding copy of the Jamabandi also not enacted lordship in the repetition.
Actually, I had filed one.
Lordship.
Then
The-
petitioner. In the meantime, the petitioner also will not be, but in the meantime, during the proceeding before the petitioner will appear before the SP border
Already she is on interim
on
lordship,
interim.
on 25.
Early interim order passed by this court on
25/6/2019.
will continue till culmination of proceeding before the learned foreigners tribunal.
Deeply obliged.
Item number 12.
Amjad Ali. Yes.
Yes, ma'am.
So the records have come. Huh? Yes, anything?
Yes.
Since the records have been received.
Item number 13.
Haralal Das. Yes.
Lordship, the petitioner was after a reference was declared a foreigner in the year 1988 within the stream of 1966 to 71.
Okay.
We accepted the order and we went for registration, but due to delay, our registration was not allowed.
Okay, and Mr. Lane Council, also Lane Council. Considering the nature of the case, we have the view that matter can be disposed of at this stage. The only grievance of the petitioner is that though the petitioner was declared to be a foreigner of the stream who had entered Assam illegally during the period of
1966 to 71.
wide order dated
uh,
10/8/1988, passed by the foreigner
Yes.
town Karbi Anglong, because of his ignorance and lack of proper advice, he could not approach the concerned registering authority
after-
within time, because of which within time, that is within 1 month.
Within 1 month.
1 month, huh?
Rule 19,
As provided in Rule 19 of the
citizenship rules.
2009.
Nine.
Full stop. The petitioner submits that the petitioner is otherwise petitioner cannot go back. Petitioner, if not registered, will be deemed to be a foreigner who would be liable to be thrown out of this country. Petitioner submits that the petitioner will have nowhere to go except this country, and as such, explained that the delay in appearing for the registration authority may be condoned. First of considering the nature of the case, we are inclined to allow this petition by condoning delay in appearing before the foreigners registration authority at where?
Lordship, Karbi Anglong.
Karbi Anglong. Tell us that particular
The before collector, as per say section 11,
that will appear for the he may be allowed to
DC
he
collector.
will appear for the with the certified copy of this order and the concerned authority. / DC Karbi Anglong.
Karbi Anglong.
Karbi Anglong will allow registration in spite of the delay.
As per
Which is
section
occurred,
11 of the.
in terms of the order dated
1980. W.
Item number 14.
Saddam Hussein. Yes, what do you want, Saddam Hussein? What do you want?
Yes, Lordship, may I plead your Lordship? And Lordship, the respondent number 3 that submitted the status report of the investigation, Lordship. on the crime.
What is this?
The petitioner for the missing, Lordship.
Huh?
In this case.
Or not a foreigner's case?
No, no, no. this-
Okay. Miss, you the submit the share, receive instruction, place sometime file the same. Have you filed?
Yes,
Affidavit?
affidavit has been filed. That is
Okay.
what record of it.
Okay, missing the, what is the progress of the case? Do you have any idea?
Investigation is still going on.
This 2110.
Hmm. No, what to do? Somebody is missing, it's unfortunate, but then missing.
For the 1 week, 1 month's time may be granted for submitting the up-to-date status of
Updated,
investigation.
Okay, we'll see that because these are difficult cases.
Yeah.
Okay. Ms. U Das, Learned Government Advocate Assam, prays for some more, for prays for a month
Miss
time to,
MDB, Lordship,
sorry,
MDB,
MJB. You are a government advocate or what?
Lordship and Lepo.
Huh?
I'm appearing on behalf of Mr. Dina.
Mr.
Dina,
Dina, okay. Okay, Miss Wenso on Devi on behalf of the Dina, government advocate, senior government advocate, prays for a month's time to file the updated report regarding the case of the missing son of the petitioner. List after a month.
Lordship.
For admission, item number 15.
What is this? Fatima Khatun, what happened?
Here, NCR has been called for and received mail.
Okay, since the records have been received, the matter will be listed for hearing.
Item 16.
Falani Bibi. Yes, Falani Bibi.
May please loss.
Yes.
Healthcare relative notice.
So we'll fix for hearing then?
Loss.
Okay. Since the records have been received, the matter will be listed for hearing.
Item number 17.
Anufa Khatun, same order? Okay, same order.
Item number 18.
Sukur Ali. Sukur Ali.
NCR has been received, my lord.
Okay, since the records have been received, matter will be for hearing.
Interim matter may be continued.
Early interim order will continue. Manoj Kumar Upadhyay, what is this?
Orders.
What is this? What is this matter?
Lordship, this is a custodial torture method to the
Hospital
petitioner.
torture.
Respondent number 2, respondent is yet to be appeared. Lordship.
Yes, who is the respondent number 2? Devi, you are there? No.
Earlier, Rahul Dhar appeared in the matter and he was taken out.
Rahul Dor, where is he? Notice Jadumoni Nath, who is identical with several authorities. Who is this Jadumoni Das?
He was the constable at that point of time working at Horolomu police station.
And police cannot find out that particulars of that constable. Huh? Or you have given the wrong name.
No, Lordship.
Ponjit Dwara,
Lordship.
son of late Putul Dwara,
And Ponjit
Official
Dwara-
Assistant Commissioner Police.
Now he is working as a additional deputy, additional superintendent of police in Huzai, Lordship.
Who? Ponjit Dwara?
Ponjit Dwara now.
Earlier he was working as
Assistant Commissioner of Police.
Assistant Commissioner. So what is this? No.
So we.
So no, except respondent number 13.
13, Lordship.
What is respondent 13? Jadunath, Jadumoni Nath,
I
Borulu Police Station, Borulu.
He
Very
might have-
near.
He might have transferred from that's why, Lordship.
Yes, who is for the other side? Dhor. Yes, why is Mr. Dhor? R. Dhor. Government. What has happened to you, your son? What happened to him?
No, Lordship, I was arrested, Lordship. in a
As
case
you were
of-
arrested.
Arrested, and I was committed to brutal torture in during my police custody, Lordship.
What kind of torture?
Lordship, I was mentioned in my petition, Lordship. I was
What
beaten
kind of
by the
torture?
hockey stick and others by means of, and I was hospitalized, Lordship, in Moran during my remand also, Lordship. And I lodged a complaint before the DCP, but no action has been taken. My simple prayer, Lordship,
Then
the complaint which I lodged before the DGP, Director General of Police and DCP, maybe it is a FIR and inquiry, maybe lodged, Lordship. Because as per Lolita Kumari, when a cognizable.
yes, we'll
offence
close it.
made,
Why keep this matter,
Lordship,
2018
let us,
matter?
Lordship, my prayer, Lordship.
Let it be, you examine and decide in accordance with law. If you find material, proceed. If you don't find, close it and give it to a magistrate saying that nothing is there. Why should we keep this matter before us?
Police Accountability Commission. We can
Annex
do it.
13, Lordship, page 14, and I have lodged a complaint before the Director General of Police, Lordship.
Just try to come.
Director General Police.
Police. And Annex 14 is.
Director General will police with consider matter and if he has not done anything, then what to do? Then let it be treated as a judgment.
Lordship,
You mentioned some judgment.
Lolita Kumari case, Lordship.
Yes, it was that. We'll close it. You treat it as a FIR, examine. Yes.
Lordship.
You given?
Lordship. No, sorry, Lordship, I have only one copy in that. I apologize. Lordship. In paragraph 120, Lordship.
How long we'll wait this court for indefinitely? No, obviously. So we'll pass order. And Mr. Lana Counsel for that, no one is present for the state.
Your Lordship, I am appearing for the government advocate.
You tell us, you tell us. then you
Since
tell-
Rahul Dhar, he is appearing in this.
Sorry, we will not allow anything like that. That is your problem. No, Mr. Ardhor, who was earlier appearing before the state, is not present today. Accordingly, we proceed, and having waited for several minutes, we are not inclined to wait any further, and accordingly, we proceed to pass appropriate orders. The matter part is, this matter is, this petition was filed in 2018, alleging certain inaction on the part of the state authorities in taking cognizance of allegation made by the petitioner that while he was detained, when you were detained?
Lordship, I was detained on 9/6/2018, Lordship.
9/6/2018, he was subject in connection with
In connection with Lordship, Bholomuk PS case number 344.
344,
Under section 1, Lordship, page 49, Lordship.
page 49.
342 under 16.
In connection with Bhorli Police Case number 344/2018, under section 120B/294/507, page 49,
Lordship.
/507/509/34 IPC, read with section 67A of Information Technology Act 2010, he was detained for how many days?
Lordship, he was detained for 3 days, Lordship.
3 days, and subjected to serious custodial torture. And accordingly, he submitted an application before the Director General of Police
As well as the DCP also,
as well as the DCP.
page 57.
And accordingly, however, having received no proper response, has filed a repetition. The records indicate that
This is all the magistrate. Has complained of injuries he has shown me his back where he has swelling and bruises all over his right hand. I do not think is a fit case to grant police custody.
Okay. Yes, we are closing this petition.
My lord.
Likho, our Mr. Lane Counsel, our from Mr. Dhor. Considering nature of the case, we are not inclined to keep this matter pending and dispose of this petition at this stage. In image says the principal respondents have not filed their response in spite of serving notice, though the office note indicates that only one respondent, but 13, namely Dadumani Nath, notice going to be served upon Dadumani Nath. In image says there was some lack of clarity about his identity. However, in our view, that aspect will not be any hurdle in passing the order which we propose to do today. Then likho for all those allegations sab likha tha na. Then however, having no order, he has approached this court. We have gone to the record without going into the without making observation as to the veracity or genuineness of the documents which have been annexed. It does indicate that the petitioner was subjected to there is an observation by the learned magistrate in the aforesaid Bhorlum case number so and so when he was produced and his further police custody was sought for. The learned magistrate had declined while order dated 10/6/2018 with the following observation, page 35, pencil marked. I have perused the FIR so and so. On present ground, arrest I has filed. I is not present to moreover the accused so and so, page 35.
Next page. Next page.
Under the circumstance, we are prima facie satisfied that the petitioner has been able to make out the case that he has suffered. He has been subjected to physical harassment, torture, torture, in which event a cognizable offence can be said to have been made out. The Honorable Supreme Court in Lalita Kumari so has held and issued a certain directions which are relevant paragraph read as follows. page 120, huh? It will live. And the circumstance will, since no adequate or satisfactory response is forthcoming from the state, we direct that the representation submitted to the by the petitioner to the DGP shall be treated as an FIR, which will be FIR by the police. Which police station? Borolu by Borolu police station, and the police will accordingly take appropriate consequential actions thereon as per law. With the above observation, direction the present police and disposed of. Yes, next.
Item number 21.
Review petition.
Lordship.
What is this? Still hearing something. This is for hearing. For hearing.
No.
Then what? Just come up today for what purpose?
For orders.
For orders. Today for what? Order what? What order we shall pass?
Otherwise, delay part is there.
Delay part is there. Okay, we'll fix for hearing. Let the matter be listed for hearing. Item number 22.
Item 22.
I am paying for fixing a date, Lordship,
Tariq did, yes.
and it was returned from
24th January.
obliged.
Yes, alone on the delay. They also delay.
No delay, my lord. My dear friend, Mr. Kalita, was kind enough to waive the portion of delay.
I see.
He pointed out that the prayer was incorrectly framed. I filed an IA for amendment to the prayer, my lord.
So we'll allow the,
That may be allowed, my lord. I may be allowed to either request my lordship to put the IA as part of the review petition so that the prayer can be read.
review 22.
What is the IA number?
I is there.
IA is there, my lord. On record, it's IA number 3654.
The present application has been filed for making for modification of the relief
Not for in the review.
relief sought for in the review petition. Having heard the learned counsel, we have the view that no prejudice will be caused to the respondent by allowing the application according to the application allowed for modifying the relief sought for in the review petition. What was the prayer you sought for in the review petition?
Review petition was a review of this honorable court's order, my lord.
Well,
11 June 2019, WPC 4369/2017.
And the pleadings made in this IA also will be considered when the review application is taken up.
My lord,
Petition
review may
taken.
be filed, maybe listed next week.
What is the review involved?
Review, my lords had affirmed the opinion of the foreigners tribunal. Certain documents were not able to have been filed from 1956 to 1963 of my father's. I was born in India. I'm an Indian citizen. Father may have crossed over from East Pakistan. There's no record, my lord. That is prior to 1956. 4th March prior to 4th March 1956. I'm basically from the Boroi Hindu community, my lord. Persecuted in East Pakistan.
Yes,
Yes, Lordship, we fix it after review petition, Lordship.
No, not finish it quickly. It's
In next week, Lordship, only 2 days will remain open, Lordship.
as per my friend's convenience. It may be. My friend has a heavy workload. We have a light workload.
Yes. List the matter again on, so take the Tariq did do. Yes.
19/1,
Yes.
19/1,
19th of January.
19th January. Obliged to my lordship. Deeply obliged.
Item number 23.
Abul Kalam. What is this IA? IA about? IA for what? IA for? This IA for what?
I was for impleading on advocate, my lord.
Who is the advocate? Why you bleeding?
He has been served, my lord, and we have filed affidavit regarding service.
Why has been implemented this advocate?
But your lordship's direction was.
Direction was there to implement him.
Implead him.
What did he
Because, my
do?
lord, he withdrawn a case.
Without informing,
My lord,
without
on the
without
basis of a
instruction.
letter Actually, that letter is not issued. by
Anyway, the application filed by so and so, so and so. What is the IA? IA have been allowed or what? Noted.
Matlab,
430.
IA number 430 of 2021.
So we allow in request Imtiaz. So we allow pleading MU Mahmood.
Yes, my lord.
They have been notice have been issued to him.
Yes, my lord, we have filed affidavit. Affidavit on 27/7/2022.
Official. Why is that? Notice have been served upon him or what?
My lord, your lordship.
Notice have been served on respondent number 6.
Yes.
I'm appearing the S Mitra for respondent number 6, Lordship.
As you are appearing.
Lordship.
What is your name?
AK Boro, Lordship.
Mr. AK Boro. Han Mr. Lane counsel for the applicant. Also Mr. State, also Mr. AK Boro.
Lordship.
Appearing on behalf of?
S Mitra, Lordship.
Is Mr. appearing for respondent number
6, Lordship.
6. So we allow this application.
Lordship.
Having had Lane counsel whether we are, we allow this application.
He might need to give an affidavit.
The respondent number 6, the newly implemented respondent number 6 may file his affidavit. If you in the main review petition.
Yes.
Main review petition. To be implemented as respondent number 6 in the review petition. He may file his affidavit in opposition in the review petition. Oh, main में लिखो. Allow in terms of the past today in so and so, Mr. So and so is implemented respondent number 6. He may be, he is allowed to file his objection or affidavit. How long will it take?
Lord, 3 weeks time.
3 weeks.
Lordship, and we have not received a copy of the review petition, Lordship.
A copy of the review petition may be furnished to Mr. So and so today. Give us.
Yes.
Right.
Whereupon he will file the affidavit within 3 weeks. Yes, next.
Item number 24.
24.
Copy of review petition.
Yes.
Judge.
Tilak Chetri. Review. Yes, Tilak Chetri. Who is Tilak Chetri?
Madam, they did not supply the copy of the review petition also in spite of.
But what is this? Do you have any idea?
But not
Tilak Chetri. Just
his ITBP, he was employed in the ITBP, my lord.
then what did he do? What did the Tilak Chetri do? He was dismissed from service or what?
Dismissed from service, my lord.
B. Acharya. Assigned reason we have heard. Satisfied. Okay, so delay was condoned.
It was condoned.
Where is Mr. Acharya? He was dismissed from service. On what ground?
My lord, that is medical ground, my lord, not medical.
Medical ground.
Yes.
Medically unfit. Okay. It has been submitted by Ms. Gaya. No one is present for the review petitioner. It has been submitted by Ms. Gaya, Lanet. You are what?
I'm from opposite party, my lord.
No, but
Respondent, Union of India.
but it is called now. What is it? CG? No, CGC. CGC, no? Okay. CGC. Lanet CGC submits that she has not received a copy of the review petition. Let a review petition be furnished to Lanet Council for the Union, Miss Secretary, and thereafter the matter be listed.
Timing item 3.
Item number 3. Shahjahan.
Yes.
Where is Shahjahan? 2019. Shahjahan Ali, Dr. Mohuddin. Somebody had come in the morning, no? Somebody was there. Who was that? Yes, madam. Your senior still arguing in court number 4.
Excuse me, I call in myself.
You call. Please call. We'll wait. But we will not wait indefinitely. We'll wait for reasonable time, 2 minutes. What is this matter about?
Contested case.
Contested case. Issue notice. Opposite party file statement. Exhibit. In examination tribunal, name is Shahjahan Ali. I am married. Voter ID. 8 children. My husband has 9 siblings. Oh, this is a lady or what? Sahajan, huh?
No, Lordship.
Then who is this? My husband has 9 siblings. Who says? DW2. Oh. Basir and Nasa. Basir and Nasa is the mother or what? Mother. I think Basir and Nasa is the mother. Huh?
Yeah.
I have 8 children. They're Azhar Ali, Rakian Khatun, Sahajan Ali. Okay. So she's the mother. Her mother's statement, I have living, I have in the plan.
I recall that this procedure is on of
Oh.
there's born on so and
Basir and Nasa, DW assisted son. Yes, Mr. What is this name of Sahajan Ali? You have been declared a foreigner in another.
This is my lord second proceeding. In the first proceeding, he has been declared Indian.
Huh?
In the first proceeding, my lord, the petitioner has been declared Indian.
Then
Second proceeding, he has been declared foreigner.
this is the
That-
third one.
This is similar to second one.
No, but the page 111, what is this?
Triple one, my lord.
Okay, not foreigner. Oh, I see.
Now,
Then,
not foreigner, my lord, lordship will find
Then
at
it
page
will be,
19.
then it will be hit by res judicata, isn't it?
Yes, Lordship, but Lordship.
Now, because see page 11, I respectfully differ with the order declaring as a foreigner. I think, then did you raise that this is barred or something like that before a tribunal?
Yes, it was placed before the my lord tribunal.
So we'll remand it to the tribunal to examine this, that he has been already declared. If he saw the same person, no further proceeding. Or
Yes.
principle of res judicata.
Well.
This, we are not going to declare you Indian or at this stage. We don't know. We don't have the record. See, page 111, Mr. Sharma, just please go through. I have Peru's judgment notice so and so in the name of Sahajan Ali declaring him not foreign. I respect to get the order. This, then we can dispose it off. What is your name?
My lord,
Please go out. Please go. What is your name? Yes, please come. You change the seat. You please go to court number 4 now. You can go. What is your name? Huh? Ar Miss Ar Khatun, Lani Council for the Ruma Khatun. Also, Mr. See, because it will be hit by res judicata. Let the examine. If he is the same person who was declared foreigner, then Khatun. And also Mr. Considering nature of the case, we have the view that the present petition can be disposed of at this stage without calling for any records. In view of the law laid down by this court in Abdul Quddus. Al Khatun. What? Tell us the full case. Abdul Quddus versus Union of India. Which year reported? Which year reported in which year? At least you should say that to justify your name in the order. 2019, volume 1, SEC. That the principle res judicata is applicable in a proceeding before a tribunal. In view of the fact that the petitioner had been earlier, according to the petitioner, he had been already declared to be not to be a foreigner by the foreigners tribunal by an earlier opinion dated 9/6/2017 passed by the learned foreigners tribunal number 3 Kamrup M in FT case number 28 of 2017. Stop. We have also gone through the impugned opinion rendered by the learned foreign tribunal. It may not be necessary to deal with consider the other grounds taken and in much as There is a specific finding by the learned foreigners tribunal in the impugn order dated 5/3/2019 that to the following effect, page 111, for pencil mark. Thus, it appears that the learned tribunal was made aware of the fact that there is an earlier opinion rendered in favor of the petitioner who claims to be Shahjan Ali, alias Shahjan Ali, son of Iman Ali, alias Iman Ali Sheikh, who was proceeded in Kamrup, proceeding of Foreigners Tribunal number 3, Kamrup M, in FT case number 28 of 2017, that he was declared not to be a foreigner. If that is so, and if the present petitioner is the same person who was declared not to be foreigner in the aforesaid proceeding, in view of the applicability of principle res judicata, the subsequent proceeding would not lie. Full stop. Accordingly, however, since the records are not before us, will require the Foreigners Tribunal M 2nd Guwahati 3 to re-examine this claim of the petitioner that he was earlier declared to be a foreigner, not to be a foreigner. And if it is found that the present petitioner is the same person in a said earlier case in FT case number 20 of 2017, the natural consequence will be that he cannot be proceeded again in view of the applicability of principle res judicata, and the subsequent proceeding has to be closed without any further consideration by the FT. Accordingly, we set aside the impugn order dated 5/3/2019. Accordingly, we put on hold the order dated 5/3/2019, not to be given effect to till the Foreigners Tribunal gives a finding to effect as to whether the present petitioner is the same person who was proceeded earlier in FT case number 28 of 2017. If the Foreigners Tribunal on reconsideration comes to a finding that the present petitioner is the same person who was proceeded in FT case number 28, the present proceeding will stand closed. The order dated 5/3/2019 stand set aside without further reference of this court. However, if there is a finding to the contrary that the present petitioner is not the same person who was proceeded in FT case number 28 2017, the petitioner would be permitted to approach this court again to challenge such an opinion of the Foreigners Tribunal as well as the order dated 5/3/2019 and take all the grounds which have been taken in this present petition. With the above observation, direction the present petition since disposed of, the petitioner will appear for the Foreigners Tribunal again on when will appear? Foreigners Tribunal
15 days.
15 days. 7th of February. You enjoy your view and go there. 7th of February. Until then, no coercive action be taken against the petitioner on the strength of the impugn order dated 5/3/2019.
For hearing, item number 25 and 26.
Yes, Mr.
Well, today I will address your lordships on the affidavit which has been filed by Union of India.
When did you file?
It was filed long back, my lord. They filed reply also.
How long will it take, Mr.
Maximum half an hour. Maximum.
And minimum?
15 to 20 minutes.
Maximum is half an hour, minimum is 15. And what about you, Gyan?
I said 20.
Maximum or minimum? You have to specify, no?
Yes.
Minimum 20. And maximum means maybe also
Not more than half an hour.
not more than half an hour. So half an hour, half an hour. 1 hour.
Before.
Huh?
Before first half.
Before first half. And there is a single bench also. I don't know why we have kept this on a, it should have been kept in a hearing day. No? Because non-hearing day, because then these other arbitrators in arbitration matters, commercial lawyers, they're eagerly waiting for their disputes to be resolved at the earliest, which will be delayed if we continue hearing. Can we fix on a hearing day? Because so that we will have a, then all this before half an hour, after half an hour, within half an hour there will not arise. Shall we fix on a hearing day then?
Yes.
Yes.
At a hearing day, you after view, perhaps you enjoy your view and come back. What is it? Huh?
Let it be on 10.
Huh?
10.
No. After view, 10th is just before. You'll be busy preparing for your view. You have to go marketing. You have to go to Kachar Ghat, to get the best fish available.
And how also.
And how also. So let it be after you enjoy your view, you'll hear it. It'll be better.
17 is Tuesday, my hearing day or 9. No.
17 will be just after the opening. No? So you take rest.
My lord will have it on 25th, my lord. 24th or 5th.
24th is hearing day, Tuesday.
26 is January also.
Or let it be on 31st, my lord.
Okay,
Tuesday.
31st. On joint prayer, the matter be listed again on 31st of January.
List over.
Mr. Arbitration is out of station.
4 and 5.
Yes, your lordship.
Durga.
I've taken the consent of the other side.
Okay. Next week, huh?
Next week, 25.
25.
Yes, ma'am.
Vacation, your lord.
I'm for respond SK reports.
Okay. And Mr.
A. Ahmed.
A. Ahmad, who mentioned on behalf of Mr. Arbitration for adjournment. Are also Mr. Medi. SK Medi. Then ASI. CCO. Now I think they should change it, no?
Yes.
ASI is the earlier.
Yes,
nominee.
Yes.
No, earlier, it
We are
was
CGC, madam.
CCC.
Yes.
Matters according to be listed after
25th of this January.
25th January.
On next week, I'll not be here, man.
Okay, 25th January. 25th January, okay?
Yes.
Okay.
Always.
Yeah,
Item number 13, my lord.
What I mentioned.
13.
Yes, my lord. This may not be adjourned for, this may be fixed for next week, my lord.
13. Who is for the you are for the petitioner.
Yes, my lord.
So joint prayer, the matter will be listed when?
Next week.
Huh?
Next week, my lord, next week. Next week, your lordship.
There is nothing called next week. There will be next month.
No, that.
Next
it will
month.
fix on Friday.
Next month. Next month. Next month. Next
1st of February.
1st of February. Next.
This is a review, your lordship.
Lordship, I beg to mention item number 12.
Yes.
If the respondent has filed affidavit in opposition, we will file reply. 2 weeks time may be granted, your lordship.
On the prayer of Mr.
A. Ahmed.
You are for the respondent.
I'm for the petitioner.
You want to file a who is
Reply
for the
to
other
the-
side? You have informed the other side.
There. Morning he was there, but now I have not seen.
Okay, you want to file and
Reply to the
Okay.
affidavit in opposition.
Mr. place for how long?
2 weeks time.
2 weeks time to file a reply to the affidavit filed by the respondent. Yes, next.
Keep your brain.
Lordship, I beg to mention item 8, Lordship.
Yes.
Yeah, I'm still waiting for instruction. I'm praying for 4 weeks time,
Who
Lordship.
is for the other side?
Yes, she is there. I'm for the.
Any objection? No objection. You are a very good friend of Sharma, I think, Vijita. Okay. On the prayer of Vijita, matter stand adjourned to
4 weeks, Lord.
enable her to get instruction.
Yes, Lord.
Also, Ms.
TJ Sahewala.
Huh?
TJ Sahewala.
Who has no objection to the prayer so made.
That may be fixed after 4 weeks.
Tarik ji do. Tarik.
As regard item number 7, my lord,
Yes.
My lord, my learned friend was supposed to file affidavit.
8th of February.
I had a talk with him also, but right now he's not. So your lordship may adjourn this matter for 2 weeks, my lord.
On the prayer, Mr. Ego, matter stand adjourned for 2 weeks. Yes, next.
May I please your lordship with due consent of the other side, I beg to mention item number 2.
Yes.
Your lordship, my senior counsel's health is not well, so he couldn't appear before this.
You are for who?
Mr. A. Bhattacharya, we are for the petitioner, your lordship.
You are for the petitioner. And the Union of India is what?
Lordship, I'm representing Mr. N. Enik Singh, respondent number 5 and A24. Ms. Senior Counsel, Railway Council, Uma Chakrabarti.
What do you want?
The
What do you-
adjourn the matter, Lordship.
What do you want from your side? He wants adjournment, but what do you want? You also want adjournment. You are not opposing. Huh? If you had opposed, you would have awarded some cost to you. But you are also appear to be a good friend of. Okay, on joint prayer, the matter will be listed again on so and so. Yes, Nick?
Much obliged.
23-1.
May I please your lordship, I would beg to mention item number 11 as the senior counsel, Mr. J. Roy is currently out of station, your lordship.
Where is he?
He went out of the country, your lordship.
Out of the
But
country.
He'll be arriving. Okay.
He will be arriving today.
Yes, your lordship.
Okay. On the prayer of Miss,
Enact.
matter stand adjourned to how long?
After the Bihu vacation,
But you said he's arriving today.
No,
Then again he will go during the vacation.
no, your lordship, it's fine.
Foreign country. Huh?
Okay, your lordship, you may
18-1.
18-1. Okay.
After view, let them go also again, go to
23-1.
again to another foreign country during view also. COVID is come. Oh, okay.
23-1.
Okay, then yes,
Daily list for admission, item 1.
May I please your lordship?
Yes.
Lordship, the railway matters are keep pending, lordship, due to central organization, the
Lordship, I'm going to file a written argument, my lord, then as.
okay, you file your written argument.
Written argument.
This, what is your name?
H.
What is it?
Medi.
Huh?
H. Medi.
Mr. H. Medi, prays for how long? Prays for some time to file a written argument.
My lord, the written argument is ready itself. I am going to.
Okay,
file
list the matter again after view did you.
23-1.
Yes, next.
Right.
Item number 3.
What is this Eastern Cargo?
Yes. We are appearing for the respondents, my lord.
Respondent is Rajkumar Mishra.
My lord.
Here Eastern Cargo, anybody there? Nobody is there.
My
What
lord,
to do?
this matter has been pending for quite some time now.
Is it so? List on joint prayer. Joint prayer. Oh, earlier you were joint. You were all joint. Now today you are alone. Devi, Bora Gohai. Chetri, Mr. R. Chetri.
Mr. Sharma, P. Sharma is here.
I don't know, we have mentioned one Chetri
Chetri.
petitioners. Sharma also there once a while. This is a petition where the lawyers pops up once a while. 6 adjournment, sometimes jointly also, joint endeavor, joint venture. For 2 occasions, it was a joint venture to adjournment. And today, what you want? Sole.
We are at,
Sole
we are at the
venture.
disposal of your lordship. As your
Correct,
lordship
but I,
pleases.
we go the other side. He wants arbitration. You don't want arbitration.
Because it is not maintainable, according to us. According to us, it is not.
Why it is not maintainable?
Because, my lord, the arbitration clause is not there in the deed of retirement.
Then from where they have drawn this? What
From
is
the
the
deed of partnership, my.
in the partnership is there.
It was there, it was in clause number 15, it was there. And it is mentioned that if the parties fail to amicably settle their dispute, then they will go for arbitration.
And then what
There
is
was
the-
an amicable settlement that has been suppressed by him.
Oh,
That has been suppressed by him. We have annexed it with our.
if there is an amicable settlement, why should he come?
My lord, now he wants to wriggle out of that amicable settlement. That's why, my lord, now he is creating.
So
all
it was
this.
not amicable according to you.
No, it was amicable because pursuant to the.
Now he changed his mind.
Yes, pursuant to the amicable settlement, my lord, the deed of retirement was made.
Oh, deed of retirement has been made.
We have come out of the. We have come out of the partnership.
Oh, no, so no more, there is no juror relationship. No,
Nothing. my lord.
we are all strangers now.
Yes. Blood relation is that of brothers, my lord.
Brothers, doesn't matter, the blood relation will remain, but no more business relationship.
No more business. Correct, man.
But then this typically happens in a family relationship, no?
The business was started by the father, my lord, who is the respondent number 4.
But why is this he's your elder brother or what?
Younger brother. Youngest.
Youngest. But it is a failure on your part. You are not able to convince your youngest brother.
My lord, money is the thing, my
Money
lord.
thing.
It spoils everything, my lord. It can do good things also, it can do bad things also.
Hmm. So he is more money minded, according to you. So what to do with this money minded younger brother? He is not represented today.
As
What
your
to do?
lordship says, that we are. to
Because
submit
see,
on
only
merits.
order which can be passed in his absence is to dismiss.
My lord.
But then on a new year, that also in January, first week of the new year, no?
As your lordship says. We will not.
Okay.
If your lordship says that we are to submit, we are ready.
No, but then the other side is not present.
My
No?
lord, as your lordship says.
Okay. Though Mr. What is your name?
My name is Z Mukit, my.
Z.
Mukit,
Mukit.
my lord.
As well as you also say?
Yes, madam.
Also,
H. Buragohai, madam.
Buragohai are present for the respondent.
I am for 1, 2, and 3. He is for respondent number 4.
Okay, are present for respondents 1, 2, and 3, and for respectively, none is present for the petitioner. However, we afford another opportunity for the petitioner to appear. According to the matter be listed, then when can you
As
appear?
your lordship.
As convenient for madam.
Huh?
Any date convenient.
After then view, because view
Of course, madam.
We are also looking for.
view is going to
Looking forward.
interfere with the normal functioning of the court. We know that. There all this preparation for view
Madam.
and aftermath of view also. They will go on also.
The festive mood is still there.
After view, did you then?
25-1.
35.
Okay.
Obliged, madam. Deeply obliged.
Item number 6.
Raitani.
Yes, your lordship.
What is the reason?
Lordship, in this case, they have filed their response. So I need to file a reply to
I
that.
want to file a reply. How long will it take?
2 weeks.
Mr.
Lordship, after the
Vishwas,
hearing,
A.
let it be
Vishwas,
discussed.
prays for 2 weeks. Prays for 2 weeks time to file the reply to the affidavit of opposition filed by the respondents.
Yes.
List view after view, give a date. Yes,
Some typographical errors there, my lord may allow us to correct it.
yes, okay.
Obliged, your lord.
31,
the
32.
Mr. Gogoi commits that he may be allowed to make the correction, the typographical errors which is kept in the affidavit of opposition
Lordship. Obliged.
is allowed.
Obliged.
Yes. Okay.
January. Supplementary list for admission, item number 18 to 31.
Yes. You said, yes, madam, you said that this Supreme Court has decided and the alternative forum, why you're afraid going to alternative, go there and explain yourself.
No, Lordship, alternative remedy, in case of this legal question, alternative remedy won't be able to answer, and they do not accept the position. So going to alternative remedy
It's a futile
will be futile.
exercise.
Futile exercise. And now the department is bringing all sorts of pleas to take the whole money, digest the whole money and just.
Then how this RIT court decide
Yes.
that we had purchased from that, that, how do we accept that?
Lordship, today I'll start from there, affidavit, Lordship. I'll take your Lordships to.
Written submission. Is your written submission?
Yes, lordship, my returns are missing.
Is thicker than your affidavit opposition.
No, lordship, I have annexed all the relevant documents also, the orders of the apex court and others.
Have you got a written submission?
I have only submitted them in idea of
It's
it.
in a different item, Lordship. This is the first matter in that there is no written information.
But are you aware of this written submission?
No.
Then both of you are saying, nodding your heads. How you are going to argue? You give a copy, then list again. Then list again. Go through this, and
Matter already settled by division bench, this main issue. And the online
that's
apex
why,
was-
that's why go through this.
Written submission will be different, but if this,
You go through it because he has, in this written submission, he has annexed many orders of, that is the reason.
Also in the apex
He has annexed the order of 12 June. He has annexed of the DN Bora. So go through this, we'll hear you after view.
Also kindly have a look at last line,
Last line of
last order of the honorable apex court, that is 27/10/2021. The separate copy lordship.
27.
10/2021. Passed in criminal appeal number 1967 of 2009 lordship.
That's why you go through this, we'll hear again next week or something.
Also already last week I supplied it.
But madam is saying here, no, you are not received. You are asking for a question. You supply then next week.
Also okay, I will again supply it.
Supply.
Lordship may take it up on Friday, Lord.
Huh?
On Friday, Lord.
Not on Friday.
Monday.
Next Monday.
9th, 91.
9, next Monday.
Monday lordship.
Lordship not on 9th, I mean, I will not be there. There's a matter fixed in Agartala. Tomorrow or day after tomorrow, Lordship?
18th of January.
Lordship.
18th of January.
Can it be after 18 or say I will be after from 23rd, 23rd.
Hmm?
I will be after from 16 to 21 lordship. After 22nd lordship. Also this entire issue already settled by the division bench lordship.
Division bench also settled.
Already settled. In
Which division bench?
2008, our high court.
No, that is regarding manufacturing, Lordship.
No,
When we bring goods and we use it in manufacturing, he's talking about that.
2008 ultra virus wala. Judgment bata.
And he's only talking about that ultra virus, that case, section was declared ultra virus.
Okay, and then then we'll hear again on
Regarding
Friday.
refund of sale lordship, that also settled by division bench lordship.
Okay, list again on so and so.
23-1.
Give these copies.
Lordship.
Yes, next.
Daily list for orders, item 9.
Item number 9. Pre-stressed. What is this pre-stressed?
Application seeking appointment under section 11.
What is the problem?
Facts, my lord, are a little bit different, my lord. In this case, the arbitrator was already appointed, the award has already been passed, my lord. So an application under section 34 would be required for setting aside. Whether your lordship will interfere in application under section 11.
Award has been already made.
Yes,
What has happened, my lord? We had raised preliminary objection as regards the issue of whether it is the arbitrator can decide in view of the judgment of the TRF Foundation, TRF case. And in a claim petition, we had raised a preliminary objection. We had raised, my lord. We have raised, my lord.
No, but then did you appear before the tribunal?
No, we had before the tribunal, we have raised that the tribunal is not empowered to take up this the type cases because of.
In that case, then you challenge the award.
No,
Because
my-
then
if my
according
lord
to
may
you,
If my
therefore,
lord,
according to you, the tribunal doesn't have jurisdiction, isn't it?
we had raised that issue, my lord.
So it was decided against you.
Yes, my lord. If my lord may kindly.
So that will form part of the challenge to the award.
My lord may kindly.
That will, Mr. How can we decide now? Because that will amount to setting aside the award. That will not be permissible at this under section 11.
2019.
If in that arbitration you had participated, raising the issue that the arbitrator is not competent, and if the arbitrator has ruled against you, that is a defect according to you, the award cannot be maintained. You challenge that on that ground before the competent forum. We will close this. There is no point. 2019 matter.
But my lord may kindly peruse, my lord. One thing.
What? Yes, tell us.
My lord, when the initially when we had the appointment was made, my lord. Appointment was made prior to the clauses which they had made in 2018.
So, no, correct. So these are all issues which were to be raised before the tribunal. And if the tribunal has made any erroneous opinion, decision, you can challenge it along with the award under section
34, my lord.
34 of that.
Arbitration.
So you will open to you to challenge all those issues Because they will close it. Mr. See, there is no point keeping what will
If my
decide?
lord may kindly peruse my objection which I raised before the tribunal, my lord.
Correct. So that has to be, that was decided against you. So that will form part of that ground for challenge in the
And-
before the competent forum under section
And
34.
In our application also, in our
This
application,
is, huh?
my lord, in our application in this section 11, we have also
Sorry,
prayed for
5,
setting aside of the consequential orders, my lord.
Sorry.
We have also prayed for setting aside of the consequential orders because what has happened, we had filed this arbitration petition in the month of February, my lord. And when the interim order was passed, there's an interim order passed by this court staying the further proceedings. On the very same day, the award was passed, my lord. And the award has been stayed by this honorable court, my lord. On the very same day when the interim order was passed.
Just you file, I say.
If my lord, the IS is disposed of, my lord, IA 1221.
Just. IA, which IA?
It is disposed of. It's an IA, it might be there in the case record. My lord, IA 1221 of 2019. It was disposed of.
In that order, what was the order
It
passed?
was stated that until further orders, the arbitral proceedings shall be remains suspended. On the very same day, the award was passed. On 15th to 2019.
The interim order was passed on 15 to 2019, my lord. Lordship knows, my lord, these arbitration matters are taken up in the second half, my lord. On 15 to 2019 itself, the award was passed and the postal receipt by which the award was posted to them shows that the consignment was booked at 12:24 AM, my lord. That means at least, my lord, 2 hours prior to that, my lord, the order might have been passed. So
Then, okay, then we have to refer to those orders then in that case.
in any case, my lord,
In any case, my
whether
lord, I will submit a written argument. Let it be taken up on Friday, this Friday, my lord.
any case, my
You
lord,
enjoy your view and come.
within an
I
application
don't
under
think
section
anything is there because see, ultimately this court cannot interfere. Once the award is made rightly or wrongly,
What we have done, my lord, we have also relying upon the TRF case, my lord.
then that saying what?
Saying that they cannot go for an they cannot appoint the arbitrator on their own, my lord. It has to be an independent one, my lord.
Therefore, in any event, arbitrator, you challenge that can be a good ground for challenging that arbitration award. It can be all good ground for challenge because see, there is no point. You can do it, nothing will happen. If you want adjournment, you adjourn. No, we don't mind. But because the award will remain. That award, defective or otherwise, unless challenge has to be given effect to. Have you challenged that award?
No, my lord.
Then you must challenge that. Otherwise, that award will haunt you.
The challenge with the way what in our petition we have prayed that consequential orders because on the same day when the stay order was passed, that award was.
But one Mr. Sharma is saying also important because the award was passed in the first half.
No, that I cannot deliver. It doesn't say the time when the order was passed, my lord.
my lord,
Anyway, then we have to consider all those aspects then. Yes. List this matter after this next month along with the IA number.
IA number 1221 of 2019.
Disposed, huh? IA number. Yes. Next.
1st of February. Item number 10.
No, it is here. Just 1221 is here.
It's there,
Just a
madam.
minute. Just a minute. Mr. Das. Chairman. And what is this by order 15 to 2019? What is that 15 to 2019?
That my lord,
It is just
in
past
the IA page 14.
page 14. No. Or Mr. Didas, this application. Until further order, there shall be stay of arbitration proceeding before 2019, na? There is an interim order. This is an interim order. It is not a final order. Correct. They shouldn't have proceeded.
and if lordship takes up page 39 of that IA, my lord, the
It's booked at 12:24.
postal receipt, my lord, Annexure 3, last document, booked on 15/2/2019, 12/24/09, my lord. So if it was booked at 12/24, my lord, at least 2 hours prior to that, the award would have been passed, my lord, at least, my lord.
So booked and when? Booked on GPO, booked on 12/24.
At least 2 hours, my lord. They'll have to arrange for everything. And arbitration matters are taken up in the second approach. It is aware of.
This is the consider award shall remain state.
It's statement.
But then see now, assuming that they had proceeded wrongly also, but then what this court will do? Can this court see the issue you are ultimately relying on your submission is that the arbitrator could not have been appointed by the railways. On what ground? That
I'm relying upon the TRF judgment, my lord.
what?
There it has to be an independent because of the amendment made in the Arbitration and Conciliation Act, my lord. So it has to be by an independent one.
Correct. That you take up all those pleas before you challenge. Because if that is so, then I will go. I will go.
But in an application under section 11, whether your lordship will interfere, that's the legal issue, my lord.
There's a problem. No? That award will go. If we will also make an observation. If obviously if the arbitrator had no jurisdiction, the award has to go. But that has to be decided by the forum. Now it has to be placed before whom? District judge. District judge. District will decide.
It would amount to patent illegality.
Then section 14 period will the period which we have time elapsed in the
So
High
what
Court.
we'll say is that you will be allowed to take all the pleas in challenging the award because the fact remains the award has been passed. And though there was an interim order, but it was a nevertheless interim order. And even though we may make it absolute, but it will not help you. Isn't it? And Mr.
Yes, Crown, my lord.
As Crown Learned Counsel for the petitioner, also Mr. B. Sharma, Learned Standing Counsel, Railways. The present petition has been filed challenging. What is the order you have challenged?
15/2000.
Challenging the appointment of the arbitral tribunal consisting of Sri Bhuvanesh Prakash Khare as presiding arbitrator and Sri P.K. Rai and Sri Harsh Kumar as the co-arbitrators on various grounds, including that, first of all, there is no arbitration agreement between the parties for referring any dispute to arbitration. Secondly, also that they being employees of the railways could not have been appointed as arbitrator
Retired.
and retired employees in view of the bar imposed under section 12,
5,
section 12,
subsection 5.
subsection 5 Arbitration Conciliation Act. It has been submitted by Mr. Khan that when this petition, when the petition was moved, this court also passed an order, interim order, to the effect that until further order, when it is moved on 15/2/2019, an interim order was passed to the effect that until further orders there shall be stay of arbitration proceeding before the arbitral tribunal comprising of response number 2, 3, and 4. Unfortunately, in spite of the said stay order passed by this court, the arbitration proceeding proceeded and also made the award on
Same day.
15 to same date, my lord.
yeah,
Same date itself.
The stay order was passed on same day and the award
And the
was passed
second
on same day.
award was passed much prior to.
appointment was made earlier. And an award was made on the same day on 15/2/2019. It has been submitted that since the arbitrator had no competency, in MHS, there was no arbitration agreement, as well as they were retired employees of the state railways. They could not have been appointed arbitrators, and as such, the entire arbitration proceeding will be a nullity in law. However, Mr. Sharma, learned counsel for the understanding of railway, submits that the petitioner had duly participated in the arbitration proceeding and also raised the issue of the competency of the arbitrators. However, the arbitrator had correctly held that had correctly rejected the pleas of the petitioners and passed the award on 15/2/2019 before the stay order was granted by this court. Interim stay order was granted by this court. Another circumstance, it has been submitted that if the petitioner is aggrieved by the arbitration proceeding or the award, he would be at liberty to challenge the same as provided by challenging the award before the appropriate forum is envisaged under Section 34 of the Arbitration Company Act. Mr. Khan, however, submits that since the arbitration proceeding was proceeded in spite of the stay order passed by this court, which was confirmed by the subsequent order dated 24/6/2019. The arbitral award proceeding as well award cannot be is a nullity. Stop. And as such, this court can proceed to appoint arbitrator in terms of Section 11 of the Arbitration Act. Next one. This court has considered rival contentions. Full stop. Before contentions, it is on. It is from the above, from the rival. It is apparent, quite apparent that the petitioners had challenged the jurisdiction and competency of the arbitral tribunal, consisting of the aforesaid respondent number 345. 234. On the ground that first of all, that on the ground, firstly, that there is no arbitration agreement between the parties to refer the dispute to arbitration, and secondly, also that there is no that the members of the arbitral tribunal, being ex-employees of the railways, could not have been appointed as arbitrator in view of the bar imposed under Section 12(5) of the Arbitration Proceeding Act. And as such, since the entire arbitration is a nullity in law, there is no bar for this court to appoint a fresh arbitrator by invoking Section 11 of the Arbitration Act. Next one. Having considered the above submissions, we have this called view that the fact that the petitioners had participated in arbitration proceeding, though under protest, they would be at liberty to challenge the proceeding, protest, since the law is now settled that arbitrator also can decide on the jurisdiction itself in view of the law laid down in.
There was a judgment passed by my lord itself in the.
In terms of Section 13, 14.
In terms of section and law, in terms of Section 13 or 16.
13, 14 and 16.
Section arbitration act.
I'll provide the section.
Now Section 16 again. Section 16.
There in 16, in 14 also probably it's there, my lord.
And also held in a number of decisions of the Honorable Supreme Court.
Vidya Dolia was there.
Vidya Doli.
As well as provided under Section 16 of the Arbitration Act. Section 16?
It's 14, 15, 16, my lord. I'll go through and provide.
Because 16, I think, competency.
16, my lord.
16 of the Act.
Competence of arbitral tribunal to rule on its jurisdiction.
The petitioner can certainly raise the issue of competency before the competent forum, provided for challenging any arbitral award. To stop. Though we have noted, this court has noted that an interim order was passed on 15/2/2019, which was made absolute on 26/4/2019. That was an interim arrangement that was by interim arrangement while the matter is being considered by this court. In the opinion of this court, even if assuming that the arbitrators tribunal had proceeded in spite of the interim order passed by this court, yet, the essential issue which remains to be considered is as regards the competency of the arbitral tribunal, which in our opinion can be best decided by the competent forum while challenging the award which have been already made. The petitioner can certainly raise all these issues before the competent forum in challenging the arbitral award. And as such, in our opinion, the interim order passed will not be any full stop. In view of the above, we have this court's opinion that the interim order passed by this court will not change the nature of the issue which is required to be resolved. As far as the forum for resolution of dispute which has been raised, certainly it will be the appropriate forum which will decide the validity of the arbitral award, and certainly not by this court in exercise of power under section 11 of the Act. If this court has to appoint an arbitrator in terms of section 11 Arbitration Act, certainly it has to first declare the said arbitration proceeding as well award as null and void, which perhaps is not permissible by this permissible to be done by this court in excess of section 11 of the Act, and which is to be done only by the competent forum as provided under section 34 of the Act.
Principal Court of Civil Jurisdiction.
That is the principal court of civil jurisdiction. Accordingly, this court will view that all the issues raised before this court can be raised by the petitioner before the principal court of
Civil
civil jurisdiction as contemplated under section 34 of the Act, where the petitioner can challenge the award not only on merit but also as regards the competency of the arbitral tribunal in proceeding with the arbitration. If there is a finding by the appellate forum, by the competent forum, that the arbitrators did not have the jurisdiction, certainly the petitioner can approach this court for appointment of arbitrators by invoking section 11 of the Arbitration Conciliation Act. With the above observation.
Appeal would lie under section 37.
Sorry?
Against the decision of the principal civil
That
court of
is not
all
the issue now.
jurisdiction, they will have to come in appeal under
Okay,
section 37.
and after exhausting the appellate forum provided under section
37.
Against 34, 37 lies.
37.
after 34, 37, no?
37.
Yes, my lord.
And the court would be, my lord, principal civil court. of-
Anyway, after exhausting the appellate forum as provided under section 37 Arbitration Conciliation Act.
The period, my lord, because the time has elapsed from
Okay,
19 to 23.
okay. Though an arbitral award is required to be challenged within a period of
Maybe a period of 60 days.
60 days to stop. Because the pendency petition of this petition, the petitioner has not challenged the said award passed by the arbitral tribunal on 15/2/2019. Full stop. The petitioner may accordingly challenge the arbitral award in which the period spent in undertaking this in pursuing this petition before this court will not be counted towards computing the period of limitation.
And the stay order, if it can be extended till the filing of the, because we will file it within a period of 30 days, my lord, because there was a stay order operating in our favor, my lord, unless otherwise they will proceed with the execution of the award, my lord.
Okay, okay.
A period of 30 days may be granted
Okay,
for
okay.
filing the section 32
And
application.
it also made clear that till a period of 30 days from today, the impugned arbitration award dated 15 to 20 passed by the arbitral tribunal shall not be given effect to, shall not be executed. Petitions and disposal of is next.
What?
Item number 10.
Item number 10, what is this?
Lordship, this is a review against Lordship order dated.
Item number 10, review
Yes.
petition, mission director. What do you want, mission director? What is the problem? Why you want review? What was the direction of this court? Let us see the order.
Yes, ma'am.
But it has to be hard, no? But
Yes,
ready
yes.
or what? I don't know.
It has to be hard.
It's required to be hard. So we'll fix for hearing.
Well, the only thing is that, my lord,
What was the direction?
direction is to pay my lord salary because his termination was
According
interpreted.
to your past order for payment arrears and release entitlement. And what is wrong with it?
Lordship, Lordship directed to pass an order under FR 54-2
A2.
1, Lordship. But with regard to his entitlement during the intervening period, when earlier also he approached this honorable court, where his termination order was set aside and he was reinstated, giving liberty to the authority to proceed with the departmental proceeding, if so desired. And Lordship, he is claiming for salary during that intervening period. And Lordship direction before to pass an order with regard to this entitlement of for salary, that was passed before Lordship passing of this order, which was not placed before this honorable court, Lordship. That is at
Please. Did you get please?
It's 139 there.
It's 139.
yes, Lordship.
Page 139.
Lordship, the first order is 136, Lordship, in excess.
No.
Yes, 37.
136 and with regard to his entitlement, 137, Lordship. Page
What is that? This is on 17/1/2019.
Yes, Lordship.
And this order was, and this court passed the order on when? On 16/12/2019.
Yes, Lordship.
So in January, you had already passed the order.
Yes, Lordship.
What is the defect? In concern, no amount should be payable. Then what can we
My
do?
lord, this.
You challenge this
No,
order.
my lord.
He has already
I have-
challenged the termination order subsequent and this order in another repetition, which is still pending, Lordship.
So we'll keep it there.
My lord,
We will raise his objection.
I have filed opposition, my lord.
Oh, doesn't matter. So we'll refer that
They
matter.
have suppressed some facts, my lord.
Whatever, that we don't want to hear that because the fact remains that,
Kindly,
see,
kindly,
Mr. No, Mr. The fact remains that the government of, see, this Sarva
Yes, sir.
Shiksha Abhiyan had passed an order on 17/1/2019. Saying that you will be entitled to area of salary for a period of 1/2/2022 up to 6/4. Now, this court passed an order for release that, and this was not brought to the notice of the court, whatever may be the
My
reason.
lord, that is why, my lord, my affidavit kindly, my lord, I want to.
So this issue will be considered in that petition.
My lord, kindly, my
We'll
lord,
recall this order. There is no point, Mr. We don't
My
know. I don't know
lord,
what is interesting.
kindly see,
So that also we'll examine that. We'll say that.
kindly see, my lord, page, my.
So we'll make an observation.
Because
We'll make an
they have withdrawn this decision, my lord.
This
In this
decision?
honorable court, my lord, read court, they
Oh,
put this decision.
Why is that? Why is that?
My lord, my affidavit opposition, my.
Why is that? Why is that?
My lord, page 13,
Page 13.
annexure Roman 1, my lord.
Page 13.
My lord, operative portion is, my lord,
Yes.
page,
17/3/2018.
yes, my lord.
How they can withdraw into open
My
order?
lord, kindly see, my lord, page 18, that this.
Page
18,
18.
yes, that decision is withdrawn.
Just a minute. When 73, which is this 18 page, when this order was passed,
That, but 17/3/18, in 18.
how can the 18 withdraw a order passed in
Page 19,
2019?
page 19, they have withdrawn, man, page 9.
Again,
17/3/18, that decision was withdrawn.
oh, how can, Mr.
Then,
Come
my
to
lord,
page 137, annexure 8.
Yes, that is 19. Prior to
then-
that, they have withdrawn. After that,
Arey,
this-
Mr. You don't know, I don't know.
Mahila-
How
my-
can you withdraw which is yet to be born?
No. What decision they withdrawn, and that was not minor brought to this records of this court, honorable court. They said that we have filed after passing this order in writ court. They
So
have
what will they, will keep this open. You take all those please. Liko Han, Mr. Lane Council for the Lane Council. The present petition filed for seeking review of the order passed by this court on, what is the order? By this court on 16/12/2019, by which this court directed the for a release of arrear of salary in respect to the period. What is that period
Mahila, one
mentioned?
1/2/2012 to 5/4/2018.
19 release within a period of 6 months by issuing the following direction, para 7, page 23. It has been submitted by Mr. Lane Council for the state that before passing order, the petition, the authorities had already declined, rejected the prayer of the petitioner, declined to grant to give the arrears. Page number
137, Lordship.
37 by issuing the order dated 6/8/2018.
That was the order of termination. Lordship.
17/1/2019, whereby it was held that no amount shall be payable to the petitioner who was proceeded in a department proceeding as arrear salary for a period with effect from 1/2/2018. However, the said order dated 17/1/2019 could not be brought to the notice of this court, while the said petition was disposed of on 16/12/2019, and accordingly it's been submitted that the earlier on this order direction of this court passed in 16/12/2019 be recalled as regards the direction for payment of arrear of salary. Mr. Mr.
MJ Borua.
M.J. Bora, on the other hand, submits that order that the authorities had passed an order earlier withdrawing
Same decision they have.
where is the page?
Page 18, 19, page 19. The dice non that was withdrawn, man. How's this?
That the pass an order also on 5/4/2018 to the effect that the order declaring that had passed an order that the petitioner shall be deemed to be in service with effect from 14/12/2016.
And earlier, dice non was withdrawn. man.
And
This-
the earlier order declaring dies non,
Page
earlier order treating the period from 18/2/20 till date of passing till date, that is till 17/3/2018 to be treated as dies non was withdrawn. And as such, the authorities cannot pass contradictory orders. This court is the view that all these issues are in next para.
Another contention I want to place. They have admitted that they should give the subsistence allowance, page
Okay.
77 minus.
Mr. B. Chowdhury, on the other hand, submits that there is another petition pending before this court being WPC number
Lordship 7026 of 2018.
in which
He has challenged the order of
Second termination.
petitioner has challenged the second order of termination dated
6/8/2018, page
6/8/2018.
136. Page 136. Lordship.
6/8/2018. And the issues regarding payment of arrear of salary can be also considered by the court while deciding the said petition. Next paragraph. This court is the view that since the second order of termination is a subject matter of consideration by this court in the aforesaid petition pending, the petitioner can also raise the issues about the entitlement of arrear of salary for the period from
Lordship 1/2/2012
to
to 5/4
5/4
2018.
18. Full stop. Accordingly, when the present petition is allowed by recalling the order dated
No,
16/12/2019, directing the authorities to release the arrear of salary, subsidy allowance, so and so and so and so and so and so, page 7, page 23, with and such entitlement is claim petitioner can be raised before the before the court in the said pending petition. Full stop. With the above observation, the present review petition stands disposed of. Yes, yes.
He is without salary 12 and page 77, this honorable court, he said that substitution will be given. That
is for the other court, no? That you make a mention before.
These court's orders are
Oh,
there. In contempt petition, their court's orders are there. Page 77.
See, this court cannot pass a review petition in respect to another
And
pending
this was
matter.
not communicated. I don't know it is not communicated to him or not. Read court.
उसमें लिखा है इसमें पहले लिखा was not brought to notice. Mr. Land Council for the Mr. MJ Barua, however, some is that the said order was never communicated to the petitioner, and as the petitioner could not have bring to notice, and it was the responsible state government to bring it to the notice of the court if such order was issued. Whether the said order was really issued or not, in view of the submission advanced by Mr. Barua, can be also considered, can be also taken up, can be also raised before this court in the said writ petition, WPC number so and so pending.
Maybe they take up or it's disposed.
No, we are disposing of the.
So
we are disposing of this really that.
We have to file separate writ petition then.
No. Therefore, so that the court can be raised, so that the court can pass an order as regards the entitlement of the arrears for the aforesaid period which the petitioner is claiming. And the petitioner also may file additional affidavit in the said pending writ petition to make to bring all the relevant facts and submissions on record. You may file an additional affidavit.
But I am appearing for respondent 4 here.
In that case, okay. Mr. also vote also in that respondent number 4.
I'm so obliged.
Yes, item number next.
For hearing, item 14.
Hearing? What hearing? What hearing, Mr.?
My lord,
What hearing?
had heard this matter for some time.
Heard.
The reply was being made by my learned friend, my lord, for the High Court.
Then today for what?
My lord, this matter pertains to the fixation of pay of one of the High
I
Court.
have forgotten everything because this is coming after how many months?
No, my lord, in December,
December?
my lord had dictated the facts even, my lord.
Facts also.
Facts and my submissions.
And then why it was not disposed of on that day?
My
Because-
lord, my learned friend's submission remained, my lord. Hearing remained concluded, my lord. Hearing continued, my lord.
Oh. You want to continue the hearing today, argument?
To your lordship,
I don't know because
subject to convenience.
and what is the submission you have to make in that case? You said that you just try to let us recollect. You are in the CBI
I was in the CPI, my lord.
and then you are given this.
My lord, I was
Okay.
drawing a higher scale.
So
I
it was
given the highest scale, the highest
and
pay.
yes, high scale. So after
But he,
after you join this High Court, you are given the
the benefit of the 6th pay commission
pay
revision
commission.
here, my lord. Though I was, I had the benefit of the 6th central pay commission revision in the CPI. My lord, there were certain decisions of this honorable court in other cases, my lord, wherein.
And why the High Court is refusing to give that? What is what is your?
Lord, the High Court did not refuse, my lord. Actually, what the High Court did, High Court protected his last pay that he got.
And what is the last pay?
19080.
Who worked out the last pay? Who worked out the last
The
pay?
CBI, my lord.
CBI also last pay.
CBI worked out the last pay, and that certificate was given to us.
And then?
So initially, he was given the highest of the pay scale, pre-revised pay scale, that was erroneously given. And later on, after when the revision was given effective under 6 CPC, that was corrected. And his last pay in the CBI, that was protected, my lord. The
See,
only
let me see
question-
on Friday, let us see on Friday, no? Let me try to recollect
Right.
the file also, maybe.
Lordship.
I remember I have heard you extensively.
Yes.
Only you had to, because
Lordship has heard me also,
Huh.
had heard me also,
then,
but then, my lord, it remained unconcluded. To some extent, Lordships has heard me. I tried to convince your Lordships, then there.
I was not convinced,
I'm
perhaps.
still trying, my lord.
Trying. Okay.
So my part was not over, as well as Mr. Borpuja.
Oh, Borpujar, you are the one who are creating all the problem. You are the finance man.
So,
How did you calculate? Did you calculate properly or wrong
Yes,
calculation?
yes, my lord, we have filed a affidavit, my lord, where we have shown the detailed calculation. Now, my lord, my learned colleague paying for the High Court, he will be justifying in detail, my lord, how that conclusion has been arrived at. Because on the basis of the data input given by the, my lord, High Court, the finance have calculated. So that's how, my lord, the matter stands.
No, file level. Let us see the file. Draft submission. In the CBI, you are getting the pay scale of 12 to 2040, isn't it?
My lord, yes, but later on it was again revised. My lord.
Revised to 55 to 9,000.
My lord, 17220 was the last in CPI, my lord.
Sorry.
17220, my lord. But that
Revised to. Just a minute. What is your calculation? You had.
my lord, I submitted a, my lord, list of dates with
Correct.
facts that has to be there in the.
Yes, it is there with me.
Last page. my lord.
And whatever, did you also submit some? No. Did you also submit?
I had submitted a compilation of judgments, my lord.
Not the judgment, but that the
Calculation.
calculation. Did you submit that?
No, my lord.
Can you submit like that? Then we
Sure,
can
ma'am.
take it up on Friday. I will make an attempt to
Sure,
dispose it because I remember
Right.
the calculation which you have mentioned. It is recorded in my order also.
Right.
But just have a glance. Challenge seeking recovery amount. Is that because all stenographer when the petitioner was serving the CBI, he responded in the pay scale. The advertisement was
My lord.
5725
To
to 1125. No,
My lord.
and at that time you are already enjoying a higher pay
My
scale.
lord, 16,000 and odd.
So when you are appointed, you are given this
11,825.
11,825.
My
Where is the order of 11,825?
My lord, at page 48.
Page 48.
So sorry, my lord, page, yes, page 48, 49, my lord.
Page 48. This is regarding fixation of no 48, 49, no that order when we are given appointment order.
Oh, appointment order, my lord, page 41, my lord.
Page 41.
26/12/2008, my lord.
In that case, what is the pay scale was in some pay scale of 1125. That is in the general pay scale it was. Huh?
My lord,
Then you are given this 1125 the highest.
my lord.
If you had entered as a fresh, you would have got it.
Yes,
But since you are already serving in a higher pay scale,
exactly.
so the moment you enter the High Court service,
My-
you are given the maximum
Of that
scale which was
Yes.
maximum of that pay scale
My lord.
which was given. So
My-
you are given 11,
825.
11.
825.
Just a minute. See, there's a whole problem of, again, breaking the chain of, gets disrupted. I remember you 11,825.
Page 48, my lord.
It's like, when you start a, race, no?
Right.
Thak. You started running, then they found it is defective. Oh, come back again. Start from the beginning.
And in pay fixation matters, my lord,
Huh?
it's in pay fixation matters, it is all the more difficult.
Ah. 11.
In the affidavit, my lord, filed by the finance department,
No, I know the problem has been, according to him, the problem has been created by you, all this problem. I don't, is it? Huh?
Yes, ma'am.
Finance has created all the problem by wrong calculation.
My lord.
We will see that. That's what we can-
she will be just, my lord, making an exercise into the amplification of this statement made in the affidavit. We have made a concise statement, my lord, given in the affidavit, as to how it has been derived at, my lord. Only to that extent.
Aurobindo,
Substance.
Aurobindo Burman,
Aurobindo Burman, yes. My lord. There, my lord, will find that paragraph 6, my lord.
paragraph 6.
Yes, paragraph 6, my lord. Paragraph 6.
So this, accordingly, the pay of the petitioner has been fixed at maximum stage of 11,825.
Yes.
In this connection, calculated pay has been above. Pay on 1
Because the petitioner had joined on, my lord, 9th of January 2009.
If I can may summarize, my lord, this in seven substance, the case is there. When he was at CBI and he came from CBI to Guwahati High Court, but he is entitled. He is entitled the protection of his last pay. That is 16,080. That was his last pay. So he legally is entitled for that protection of that particular pay. Whether he is entitled for 11,825 that was given to him, highest of the pay scale, whether he is entitled to that or not. That is the question. Because he was not even born in 11. Normally, if a person comes from, is appointed on direct recruitment, he gets the minimum in normal circumstances. If a person joins on direct recruitment.
Yes.
So the advantage he is getting is that protection of the last pay drawn, which is higher than the minimum of the pay scale.
Now, in that last pay drawn, it is shown to be pay ban is 12,666. Then the grade pay is 12. That is what the last pay is by the.
Here, lordship, if your lordship goes to the pay ban and the pay scale, it will be more confusing. Plain and simple case is that, my lord.
What was the last pay he was getting?
Last pay he was getting is that 16,860.
When did he join? He joined on?
He joined on 9/1/2009.
9/1/2009.
And the last pay certificate.
9/1/2009 in Guwahati
My lord.
High Court.
CBI. Yes, he joined on High Court. Yes, sir.
9/1.
I'm sorry.
So when he joined the Guwahati High Court on 9/1/2009, what was the pay he was getting? Salary.
His pay.
See, his pay has to be protected, no?
Yes, 16,860. His pay was 16,860.
16,860.
Yes, that pay is required to be protected and he is entitled for protection of that pay.
So pay ban, if you see, come to pay 16, pay ban is 12,660 and grade pay is 4,200. Altogether 16,860.
Yes.
So so he'll get as per that. Then what was the problem?
16,860
Yes.
is to be protected.
Correct.
Now, what the High Court erroneously has done is that he was given the highest of the pre-revised pay scale,
And
As-
what was the highest river period?
11,825. He was not entitled to that, Milo. As per FRSR,
22.
FR 22-1A1, he was entitled to protection of this 16,860. Since the Milord, at that point of time, the ROP rule was in a flux, Milord. The 6th Pay Commission recommendation was not implemented. So
No, no, see,
erroneously,
if you read para 6 of the government, no?
yes, madam.
As regards the statement made in para 14, repetition dependent on the to say, since the incumbent concerned, the petitioner had joined on 9/1/19 as stenographer in the office of Research General Regime so 1680, payment so under so according to pay of the has been fixed at maximum stays of pay at 11,858,11,825. And what is this 11,825? 11,825. From where you get this?
It's the highest of the scale, my lord, 5,725 to 11,825.
It is the
In
highest of
para
The pay of the
11,800.
fixed.
That was the wrong committed by the High.
No. 11,825.
Yes.
See, and according to the pay of the has been fixed at maximum stays. Now, this government doesn't say that it is wrongly fixed. Why is it? Why the government says it is wrongly fixed?
You know, the government has said,
Government says, yes, it has been fixed, but
They have-
government does not say that it is wrongly fixed.
the government has.
Para 6, no, please read para 6. And the pay of the has been fixed at maximum scale of in the pre-revised scale of so and so under the provisions of 2222 FR. In this connection, the calculated pay has been given below. Pay on 9/1/19 excluding grade pay. Why do you exclude the grade pay? Why excluding grade pay? Why you explain? I don't understand.
Yes, that lordship may kindly see, my lord, page 52 of the writ petition. Page 52, there, my lord, the calculation is there.
No, forget their calculation. Forget their calculation. You are the one who was supposed to.
Excluding grade pay means the basic pay, my lord.
That is the basic pay.
12,660 was the basic pay because increment has to be calculated on the basic pay. 3% increment, they have calculated on basic pay that which comes to 510.
Yes.
Thereafter, the grade pay was added.
No,
The
no,
new grade pay was added.
pay on excluding grade pay.
Grade pay, my lord, will kindly see, my lord, excluding grade pay, it comes to, my lord, 12,660. Thereafter, my lord, it is an increment of 3% is added on rupees 16,860. It comes to 510.
No, but when you add increment on again, why you want 16? Why not in the grade pay only 12660?
Grade pay will be constant. The variable component will be, my lord, the pay, that fixed pay, my lord, on the basis of which, my lord, the variation occurs.
Grade pay
Grade pay-
from why you get it 12660 grade pay? There is a pay band.
Yes, my lord.
It is the, my lord, basic pay of the CBI, last pay drawn by the applicant,
Just
petitioner in the CBI.
11825. No.
Lordship will kindly take that list of dates that will help you, Lordship, where I have.
When you say the pay scale means what? Pay scale means only the basic pay, or does it include grade pay?
Pay scale means is that, for example, this
It will.
5,725.
No. Say for example,
11,825.
when you advertise in page 41, it gives certain pay scale.
Yes, madam.
Well, this is only the pay band, but it doesn't include the grade pay. Because see 11825 is a see again 11825 when you say pay stage of pay 11825 from where you get this? There is the maximum of this.
11825 is, my lord, available in the advertisement itself.
Okay.
Page
That is
41.
a pay scale, man.
It is the pay scale.
My lord, if I may clarify, my lord.
No, he will be entitled to 11825, isn't it?
Yes, in fact, now he is getting more.
No, in the previous scale of so and so. In this connection, the calculation of is given below. Pay on 9/1/2009, excluding. Anyway, we'll try it on Friday. Let us see. Because this para 6, I'm not able to understand.
Yeah, that's what my lord on the last occasion, my lord,
Yes.
because since on the basis of the data, because in the advertisement is my lord floated by the registry of this honorable court. Where my lord, the scale of pay up to maximum amount, it is my lord 11,825.
Yes,
11,825 at page 41. Lordship has seen it, my lord.
yes.
Now thereafter, my lord, on the basis of the data and inputs given by the registry, my lord, the finance department has taken a call, and also, my lord, the views of the judicial department was also taken.
So this
And
is,
now it comes to, my lord, this calculation. Now, how this calculation is derived at, in consonance, my lord, with FR 22-183 and FR 15, my lord, we'll have to amplify. My lord.
okay. So
That's
let us
all.
see this para 6.
Only to that extent.
Yes, yes. We'll examine this para 6.
Facts and figures.
You also have tried to find fault with this para 6.
It is completely wrong, my
Oh,
lord.
I see.
It's completely wrong. I'll submit that. This Friday, my lord.
Two more cases. What are those two more cases? Yes,
Item number 15 and 16.
Deeply obliged.
And so.
Much obliged.
15 and 16. What are 15 and 16? What is this review petition? What is it? Nasir Laskar, what is this? Huh? What is the Nasir Laskar? What is the review? Nasiruddin Laskar, what is this? Subrato Purkasto.
I'm here.
Huh? Who has filed this review petition?
My lord, I have filed review petition, my lord. Your lordship, my lord, pass one order.
Oh, he's already 150. No? Okay.
At 2 p.m. my lord.
We'll Friday, we'll sit on Friday. Today there is some work.
Next Monday. My lord, then. Next Monday. Monday.
Monday, okay, Monday. Monday.
Monday night. Item 17.
17 also, what is this? Arbitration petition, Kandapara? Yes, ma'am.
Senior counsel is in code 6. So.
But this is 22 Kandapara Chalia. What is the matter? You have any idea?
It's regarding appointment of an arbitrator.
You want, what is wrong with that? You appoint any problem?
I say that the arbitration agreement, there is no arbitration agreement itself, so I am opposing that.
Oh, there is no arbitration agreement.
So, since her senior is not there, it can be taken after the review petitions. Lord.
Okay. On joint prayer, the matter will be listed after verification. After verification.
23-1.
Can it be on 24th?
24. 25th.
25th. Obliged to lordship.